to Legally Speaking with me, Tarun Nangia. Today in our ongoing series on Justice Chandrachud, who takes over as the Chief Justice of India on 9th of November, the 50th Chief Justice of India, and we will reflect on his tenure in a sense. What are the opportunities? He's getting such a long tenure. We have 2 years after a long time. We have a Chief Justice of India which has a 2-year tenure. What all can be achieved? What are, in a sense, he's a very vocal judge, so we all look forward to also his utterances during the course of his tenure. He actually speaks his mind, and we get to know it time and again whenever we see him giving a speech at various forums. And also on the bench, he's also stood across for a certain set of values, which he also articulates when he's speaking in court. We get to discuss all of this today, and I have a very eminent panel who joins me today on this. May I welcome Senior Advocate Saurabh Kirpal. Good to see you, Mr. Kirpal, and looking forward to some interesting interventions from you. I have with me Senior Advocate Arvind Nair. Good to see you, Mr. Nair. I have with me Advocate Saket Sikri. Good to see you, Mr. Sikri. At the outset, may I request Senior Advocate Saurabh Kirpal that in about the next 2.5 to 3 minutes, if you could lay the ground in terms of what are his expectations from Justice Chandrachud, and as also the hopes. Over to you, Mr. Kirpal.
Well, thanks for having me, Tarun. You're right. Justice Chandrachud has a substantially long tenure, and I really hope he uses that time to make lasting institutional changes. And I think the biggest institutional change that is required to be done is to make sure that whatever change you bring about persists beyond just the tenure of a particular Chief Justice. We've seen it too often in the past that a Chief Justice comes, makes some changes, then another Chief Justice comes and thinks they will reinvent the wheel, and this circle goes on and on. And for that, I think it's very important, and I think Justice Chandrachud is capable of this, is to carry his entire court along with him. It should not be merely a case of a person ruling from the top. It must be a case for everybody being taken together so that the decisions henceforth taken by the Supreme Court are collegiate truly in nature. So I think that's one of the most important things that he must do. In that, lots of reforms are also called for, which will require Justice Chandrachud to give up some of his powers, I think, as a Chief Justice. For instance, I believe if you have to take a decision about how rosters are determined, if it is important that we have a collegiate form of functioning, maybe other than just the Chief Justice, the senior judges must also have a role to decide how all this happens. So he must give up some of his power to ensure that in the future, this allegation that happens often against the court of preferred benches being sitting, that goes away. So I think that will be one interesting issue. And I think the appointments process will be something that we will have to examine very, very closely. I believe personally that the executive should have some kind of a role in determining the appointment of judges, but that has to be done formally, not through an informal backdoor method of discussion where sometimes discussions are replaced with innuendo and considerations which have no place. So I hope, and the law as it stands today is, rightly or wrongly, I believe wrongly, but it is the law today, that it is only the judges and the collegium which will appoint. So, well, as long as that is a law, you may agree with it, you may disagree with it, it must be enforced in letter and spirit. So let's see how that also plays out. So I think these two reforms are something I'm looking forward to seeing.
You're looking forward to. Thanks for sharing that opening comment. I'll go across to Senior Advocate Arvind Nair for his opening comment.
I think Saurabh has set the ball rolling with talking about lasting institutional changes. As far as I'm concerned, given the time that we've all just gone through, I think a very, very important idea that was of what Justice Chandrachud has been a votary has been digitalization of the Supreme Court, the use of technology. And I think this is only going to now increase in his, as you said, long tenure. I think this is going to increase, and I think that's a step in the right direction, because even though we do now have extensive use of technology, we do have virtual hearings, but across different courts and tribunals, there is still some inconsistency. The regulations and the norms that various courts and tribunals are following are a bit different, and they should be, because we are a large country. We've got local factors that come into play. I think a lot of young lawyers who got an opportunity to appear before the Supreme Court which they would have not normally got. Maybe somebody, sitting in Nagpur or somebody sitting in Coimbatore. I think they are all hoping and looking at him that this whole use of technology, digitization of the Supreme Court, maybe live streaming. I think it's already happened. Steps have already been taken for live streaming. I think there is going to be some consistency for these steps, and it's a step in the right direction. I think I said on a previous show, Tarun, that this was an idea whose time has come, and the pandemic, every unfortunate occurrence has some positive consequences as well. And I think this is a big positive takeaway that we took. And I think at some point, Saket was also involved. In fact, a year or two ago, there was a lot of resistance to this idea. There was a signature campaign, and my young colleague was involved with that. I think we are going to have some consistent movement on this. So I'm quite looking to see how that unfolds.
Okay, thanks for that opening comment. I'll go across to Advocate Saket Sikri for his opening comment on Justice Chandrachud.
Thanks, Tarun. Thanks for having me on the show. So, of course, both Mr. Kripal and Mr. Nair have spoken and set the ball rolling, but I'll start with a personal note. This is way back in 2003, when I think I was in the final year, and I had gone to Mumbai for a moot court competition representing my team. We made it to the finals, and just before the final round was to commence, there was a tea. So obviously the rules of the game were that we were not supposed to disclose our identity, and the judges are not supposed to disclose their identity. And I met a very young and a smart-looking gentleman who I thought is a final year student of the Bombay University itself. We interacted, we had a good tea. We were not supposed to disclose anything. He just gave us some tips, like a senior would give it to a junior in a law school. 15 minutes later, I saw the man on the bench, and he was none other but Justice Chandrachud himself. So a very young, dynamic-looking judge. It was a great panel of judges who judged us: Justice Chandrachud, Justice Vasavdar, and Justice Sri Krishna. So after the moot court got over, we met him outside, and I, went up to him and I said, "I'm sorry, sir, I did not realize that you're a judge." And then he dropped us to a hotel in his car. So such humble person. I mean, there is a sense of euphoria now that such a dear person and a dear judge is becoming the Chief Justice of India. I can't forget my first experience with him. And throughout his tenure as a judge of the Bombay High Court, as a Chief Justice of Allahabad High Court, where he made substantial difference, and now, of course, the judge of the Supreme Court, he's been a people's judge. He's reached out to everyone, and he's given such judgments, which are the need of the hour. Some concepts like transformative constitutionalism, etc. He's put forth in his judgments. So I am obviously looking forward to a great jurist taking over at the helm of the affairs, taking over the judiciary. And talking about e-courts for a minute, it is the need of the hour. As Mr. Nair rightly pointed out, that I was a part of the campaign when the whole drive of e-courts started. Now, there was a movement in the middle. There was some set of people who were not liking the concept of e-courts, etc. And we started this as young lawyers. We started this whole concept of continuing to do the e-courts, because you can end up participating and practicing in the Supreme Court, and at the same time arguing it before various high courts, having the whole paperless court approach. Now, if we have the Chief Justice of India who's driving it from the top, I'm sure there will be some protocol. Of course, there are right now, as Mr. Nair pointed out, there is NCLAT following a different procedure. There are various high courts following a different procedure. But if the numero uno, if the Chief Justice of India sets the ball rolling in this format, where he wants his courts to be paperless, where he wants his courts to be through an electronic medium, I'm pretty sure things will fall in place. And 2 years is a long tenure, not only to have the protocols in place, but also for, I believe, for the trend to be set and continued for a long time.
Thanks for that opening comment. I'll go across, and taking from what Advocate Saket Sikri said, I'll go across to Senior Advocate Saurabh Kirpal. Mr. Kirpal, there are some times when in a little time, too many things happen. And on other times, even through long periods, nothing happens. If you go through history, there have been periods like that. So Justice Chandrachud has a tenure of 2 years, much lesser than what his father had, Justice Y.V. Chandrachud. He had, I think, a 7-year tenure, if I'm not wrong. But in these 2 years, do you think that India in its court system will take the digital leap? And also, how do you think it will benefit litigants? It will benefit counsels and also access to justice. Could you delve on these issues?
Sure. I think it's a crying need of the hour. A whole system was devised during COVID as a reaction to a problem that was being faced. But in that reaction, we saw a great opportunity. The internet and video conferencing allows in the Supreme Court a lawyer from the farthest reaches of the country to come and address matters. And so that need that is often said that we must democratize the Supreme Court, we must have different benches across the country, all of that will actually disappear. So you can ultimately argue as a lawyer. So that's really good for the bar because they get to argue before the best benches and the best judges and learn from there. It helps the judges as well because it also teaches them what are the different kinds of bars in various parts of the country. Today, a collegium or a judges sit and decide about appointment of different high court judges without actually having had that particular lawyer ever appear before them. So it will be good also for the Supreme Court to see as to who the bench is. But I think the most important thing, and this is something that the other two panelists had touched upon, is ultimately the act of adjudication is a democratic function. It's very much part of democracy. It's part of our constitution, which requires the most vulnerable citizen of the country to be able to see what is going on in the court. As of now, Tarun, all court proceedings are shrouded in secrecy. Simply because you can't actually have access as a litigant or as just a curious observer of the playing of democracy in our country as to court proceedings, what is happening. You read some of it in the newspapers the next day, but often that reportage is, I think, skewed or tilted, and it possibly cannot capture the nuance of the moment as it is happening. So it's very important from a democratic point of view that to give greater legitimacy of the process of adjudication, that we have access by YouTube or some other channel or Supreme Court's own channel, that the common person gets to see what is happening in the Supreme Court. But of course, that is at the level of the Supreme Court. And Saket is right that just because he is at the top of the apex of a judiciary, of the pyramidal structure, a message will percolate down that it is not just the Supreme Court or court number one in the Supreme Court which will turn digital. It is the need of the hour for all tribunals, courts, and other fora to become digital, to become truly digital. It's not something that is an inconvenience. That should be seen. If
I may ask you, do you think Justice Chandrachud also will take a lot of doing to push it through judges, because not all judges may be very keen to adapt to digital? There is a certain hesitancy to adopt technology. You are hesitant that you don't want to. Do you think that will take some doing?
Look, hesitation, of course, there will be. Right. There are judges who, while lawyers are used to their paper files, they've always done this. But then there are two things. One reason that I find that the judges are often hesitant in adopting this novel technology is because the infrastructure is just not available. The requisite technological infrastructure has not been made available to the courts. Often you can't hear when the other side is arguing, there's a failure. So it's important for the judge, for Chief Justice Chandrachud, to ensure before he tries to convince other judges, he must ensure that the executive gives appropriate and proper infrastructure to all courts so that there is less reason for these judges to complain. We must also understand why is it that judges are complaining about the fact that there is e-court. It is not because they're just old or that they are just stuck in their ways. There is a real problem that the infrastructure does not work at times to the manner it should work. So hopefully...
that's a fair point that you've made, and I'll take it forward to Senior Advocate Arvind Nair. Mr. Nair, during Justice Lokur's time, if I'm not wrong, the e-court budget was about 1650 to 1700 crores.
Yes.
It's quite less for a country of India's size. Do you think that this budget should grow in multiples for the infrastructure build-up? So that the problems that Senior Advocate Saurabh Kirpal said that may happen, that shouldn't happen. Do you think that would happen in Justice Chandrachud's time, getting more funds from the executive to improve the court infrastructure?
I think that is the need of the hour, and that is the only way forward as I see it. Like I said, sometimes innovation comes in quite suddenly. And I think e-courts and VC hearings and conferences and preparation and everybody carrying their files has come in quite suddenly. I'm sure Apple and all the other companies are laughing all the way to the bank at the number of iPads and tablets that have been sold. But having said that, I think it's come in suddenly, but now there is no going back. There can be some coordination and there can be some regulation, but there is no going back. I must tell you personally, I still attend some of my hearings with paper files, but I think those the days of paper files are numbered.
But Mr. Nair, if I may ask you, do you alternate between digital appearances and
I do. That's one. And sometimes on a daily basis. And I'm sure my colleagues also do that. The other thing is that now, the preparation part of it, the practice of law is not only what we do in court. That's one aspect of it. The other aspect is the conferences, the briefings. Now, I think 90%, I'm sure Mr. Kirpal and Mr. Sikri will agree with me, both having very busy practices. I think 90% of briefings and conferences are now by virtual mode, whether it's Zoom, whether it's the platform can differ. But those days when people would actually physically troop down to your offices and that all that coordination, somebody coming in, Delhi is a big city. And when we have issues of traffic, somebody coming in from Gurgaon, somebody coming in from Noida, somebody coming in from elsewhere, those days are long gone. I think now everybody is only a click of a button away. So that's one part of it. As I said, there is no going back. Secondly, as Mr. Kirpal pointed out, there is also a larger benefit. That is this, the social and political call of having various benches. Now, if somebody sitting in Coimbatore, Nagpur, Hyderabad, Chennai, anybody else, Patna, Gorakhpur can also attend a hearing of the Supreme Court if it's happening by virtual mode, then that sort of obviates the need to have benches in various locations. So that is a benefit. The third aspect here is, as I said, I think, as Saket rightly pointed out, that incident, I must also give a similar anecdote. The first time I appeared before Dr. Chandrachud was when he was Chief Justice in Uttar Pradesh, and I was appearing in a matter at the Lucknow bench. And I had this, my team and me, we all had the same reaction which Mr. Sikri is talking about, which was that, this person hearing us is so young. Can he actually be a judge? And he was the Chief Justice, obviously. So that's one part of it. And I think he's very encouraging to young lawyers. I think if you today go to the Supreme Court, the buzz in the corridors is that there are several judges who are like that. But people often talk about how encouraging he is to young lawyers and what a patient hearing young lawyers get. And I think the thrust on technology and this encouragement of young lawyers, they go hand in hand. And of course, the other thing is, last thing, is saving of costs.
Yeah.
One of our rapidly developing fields is arbitration, international arbitration. Sometimes it used to be a task to get a tribunal to have a sitting together. You had a retired judge who was stationed in Mumbai. There was somebody stationed in Odisha. Now it's so simple to get them all together. And of course, international arbitrations, 8-10 lawyers all sitting in a flight, trooping to Paris, Singapore, or wherever the venue was. All those problems. So this is one thrust. If the budget increases, if this becomes the norm across the board, there are going to be multiple benefits.
That's a fair point that you shared with us. And I remember my conversations with Justice Sikri, where he also delved in detail on arbitrations conducted through digital mode. That was a very interesting insight, which is on some other show. But I'll go across to Advocate Saket Sikri at this point. Mr. Sikri, you appear before various forums. There are the Delhi High Court, the NCLT, then the Supreme Court. Now, in a particular day, to do multiple forums is a bit difficult. But if you have appearances, do you think this digital push will help in case you're in the Supreme Court, but also want to make an appearance in Delhi High Court or a tribunal? Do you think this should be, in a sense, institutionalized? There should be an option, unless you have a 1.5 year final argument that you have to make for an hour or 45 minutes. At least on miscellaneous days, do you think that all across there should be an adoption of digital? And if you have any suggestion to make, because you also have an experience in doing all these cases digitally now.
Tarun, I have been an advocate of virtual hearing and now hybrid hearings. I have been mooting for hybrid hearing throughout the pandemic. And I feel, as you rightly said, it is especially for miscellaneous hearings, especially on a Monday and a Friday in the Supreme Court, we can practically have virtual hearing as a norm. And, one very interesting point that Mr. Kripal just made on the show, that there are lawyers from all over the country who will appear before the Supreme Court. Some of them may be considered to be judges. As Mr. Kripal said, that perhaps the Supreme Court Collegium is sort of deciding on a name which perhaps the person would have never appeared. But now with this digital courts or through a VC hearing, the collegium itself might get a chance to hear that very lawyer appearing before them. So these are things which are very important for today and how to go forward. Personally speaking, about paperless courts, for me it was a necessity which became a norm in as much as for the last 2.5 years I have not used a single paper while arguing any matter. For 2 years, I have been restricted to iPads. And how it happened was that during the pandemic, the first matter that I did was way back in April 2020, and I had some papers in my house. So I printed out the brief. But by the time the next matter came, etc., there were no papers and there was a lockdown. So I had no choice but to start using my iPad. And from then to now, I haven't used papers at all. So this can become, it's a mindset. I personally today feel more comfortable using my iPad. I can switch through applications. In one app, I have my Bear Acts, I have my judgments, I have pleadings, notes, everything. Mr. Kripal has seen it many times in hearings when we've been together. It's very easy to sort of bookmark. It's actually easier. It's simpler to maneuver through a brief on a digital platform as against a physical paper file. So for me, the days are not numbered. For me, the days are gone when it comes to paper filing. And I believe this should become the norm, number one. Number two, coming back to the concept of virtual hearing, another very important point is, it can really help a lot of working mothers if we have virtual hearing. And I've seen it closely at home. Working mothers have to divide their time. And even we also as parents, I would say, we all take care of our kids. Many a times you can spend time with kids while doing this hearing in your office. Many a times you can spend time in office working on other things while waiting for your matters. So according to me, Monday and Friday in the Supreme Court and most miscellaneous hearings in the high courts and tribunals should become digital. That should be the norm, and that is how the future is, and that is how we have to go ahead. Yes, there is a need for infrastructure development, which is again a very interesting point Mr. Kripal made and Mr. Nair also agreed. As a Chief Justice, he will not only be able to set the ball rolling for the other courts, but perhaps will be able to work around with the executive to get more funds to have digital courts. What we see in our practice areas are Supreme Courts, High Court, and some tribunals, where there is still infrastructure in place. But there are so many other places and so many other cases and so many other tribunals or perhaps courts where these infrastructure has to go down. So this 2-year period should be, I believe, Justice Chandrachud will utilize it to have this effect right up to the rock bottom from the top. And we will have a very interesting 2-year tenure looking at digital courts, looking at a paperless brief. And by the end of 2 years, I believe it becomes a norm. And we achieve this target of an e-court as we all desire.
I think Justice Chandrachud may be happy listening to your strong endorsement for what he's been vociferously talking about. And
coming back to the arbitration, just quickly, look at what Mr. Nair said. It saves a lot of costs. Putting a tribunal together in an international arbitration was a task. Why go far? This very show that we are on, in the olden pre-COVID times, you would have booked a venue where 3 of us would have been struggling for our time. Somebody could have been stuck in a traffic jam. But here at the click of a button.
And I have faced those days. I don't want to go back to them.
Multiple shows, waiting for one senior to the other lawyer. All this is now, it saves a lot of time. And after the show, we'll be back to our desk doing other things.
That's a fair point.
I believe.
Now we will move. That said, we now move to a round of closing comments. We wish Chandrachud the best for his 2 years tenure. The nomenclature for this series is hope. There is a lot of hope when Justice Chandrachud is going to become our Chief Justice. We will start with Senior Advocate Saurabh Kripal.
Just riposte earlier to Mr. Sikri's comment about how he's gone paperless. It's true he's gone paperless. The only paper he now sees are checkbooks. That I think, and that's something we lawyers do. And that is, of course. Now, speaking on a matter of hope, as a citizen of India, I look to the Supreme Court as the ultimate protector of our fundamental rights. To me, it never comes as a surprise that an executive or a parliament will try to make sure that its bidding is done. And in doing so, they will inevitably trample upon the rights, not just of minorities, but often of majorities, because that is how governments are across the world. And to ensure that there is no such tyranny, our constitution makers, as constitution makers across the world, enshrined fundamental rights and gave a court, the Supreme Court, to ensure that every citizen's voice was equal and heard. And that is the hope I have from Justice Chandrachud, is that he will ensure that the promise that has been given in the Constitution of India, that the rights of no matter how small a person you are, no how minuscule a minority you may be, no matter where you come from, without fear or favor, you should be able to approach the Supreme Court, and the Supreme Court will give you justice for your fundamental rights. There's one thing to say about economics and other adjudication that happens in courts. That's all well and good. And that's, of course, one of the functions of the courts. But I would say in a democratic institution, and particularly in the Supreme Court, the ultimate role of the Supreme Court and that of the Chief Justice as its titular head, as well as a head who, through powers of his conscience and power of example, leads the entire judiciary in the country, must put down a message firmly that we are standing on the side of the individual. We are standing on the side of fundamental rights. It is not a battle between the state and some crook. It is a battle between an individual who has claiming his or her fundamental rights versus a person or an authority or an entity seeking to take that away. So I hope the learned Chief Justice, as he soon will be, will draw that balance and come down in favor and speak in a voice of the voiceless and apply a balm to those who need a balm to be applied.
Thank you for that profound comment that you gave as your final comment. I'll go across to Senior Advocate Arvind Nair for his final comment.
As we've all discussed, every Chief Justice brings his own flavor to the court. And one of my colleagues mentioned that Justice Chandrachud can be expected to carry the rest of his colleagues with him. So that is very important in the sense that those reforms, whatever reforms come in this time, they will be long-standing and will not be a temporary change that we see. The other thing is that three things I must point out. Now, what Mr. Kirpal is talking about, that sense of applying a balm and that being a votary and being also looking after whatever rights are canvassed. I think it also comes from one or two factors. One is that, he's also heavily involved in academics. Now, I'm given to understand that he's, in fact, despite the demands on his time, Justice Chandrachud has remained involved in legal academics because he had a position as a visiting professor of comparative constitutional law at the University of Bombay between 1988 and 1997. And I think that is a big factor in the way his demeanor is. So that's one. Two, he's also prolific as far as his work is concerned. I'm told that he's already authored 513 judgments, been a part of 1,057 benches. Also, possibly amongst all sitting honorable judges, he's actually written the most number of judgments. The third is the demeanor in court. There was a recent incident where he was sitting wrong. And in fact, that's been a norm with him, even when he was a judge of the Bombay High Court, when he was a Chief Justice of a state high court, and now in the Supreme Court, to give a very patient hearing. Tarun, at the end of the day, and this is more true about young lawyers and those who don't regularly practice in the Supreme Court, the result is not that important. What is important is that you must get a patient hearing. And I think he's an example of that. I don't think anybody who stepped into his courtroom can say that we didn't get a patient hearing. Sometimes what happens is it is the Honorable Supreme Court we are talking about. They have so many issues. Sometimes private disputes, which and they can mean the world to the parties involved. But if you see from the top-down perspective, they may not be as important as a dispute between two states or a constitutional reference. So sometimes there is a tendency that these kind of disputes get less time. It's very natural for a bench to say that, look, you've had 2 or 3 adjudications against you. Why should we devote time? But I think that has not been the case in his courtroom. Whether it's a private dispute, whether it's a state reference, the kind of hearing that is being given is extremely patient. The time that is allotted, there are no restrictions on time. And I think those are the little takeaways that overall are positive to every lawyer, and including lawyers who probably are not based in Delhi and who are not practicing on a regular basis before the Supreme Court.
Thanks for that closing comment and those points. I'll go across to Advocate Saket Sikri for the final comment of the day.
Yeah, thank you, Tarun. So I'll borrow an expression used by Mr. Kripal for Justice Chandrachud: promise of the Constitution, promise to the Constitution. That's what we are looking at. And there is a sense of excitement. We all are very excited when he takes over as the Chief Justice of India. He will set a lot of norms, and he will set a lot of new precedents for many, many years to come and follow. And I sincerely hope that all the promises that we have made to the Constitution are fulfilled during his tenure.
Thanks for that closing comment. So with this, we draw to a close our series on Justice Dhananjay Chandrachud. But this is not the last. He will give us many opportunities as the Chief Justice of India to record shows on him. And I'm sure this panel will oblige if I invite them again, because there will be judgments to look forward to. There will be observations that he makes times and again. And of course, there will be his speeches, which we get to hear at various forums. But for this time, it's time to bid goodbye, and we wish Justice Chandrachud all the best for this tenure. I would like to thank Senior Advocate Saurabh Kirpal, Senior Advocate Arvind Nair, and Advocate Saket Sikri for sparing time and joining us. And viewers, thank you so much for joining in. Thank you so much.
Thank you, Tarun. Thank you for inviting us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.